let's go ahead and call this meeting to order. Oh, wow. Because I'm loud enough, my kids already can hear me, so. Okay, so we are going to call this meeting to order. The first thing we're going to do is we're going to have a reading and the approval of today's agenda. I'm not going to read it out. I'll let you guys take about a few moments and read it, and then I'm going to call for a motion to approve today's agenda.
Thank you.
So at this time, I would like to call for a motion to approve tonight's agenda for April 24th, 2023. And can we get a second for the?
I second.
Okay. So ordered. The next is going to be for the approval of the minutes of March the 27th.
Motion approved.
Second.
All right, motion approved. Thank you. And at this time, Ms. Giovanelli, we have your board member welcome report.
I'll be quick because there's a lot going on today. It looks like we've got a full agenda, but real quick, we're just winding down the school year and looking for the next school year, starting planning for next year, so the 23-24 school year. And so just welcome everybody and let's keep this meeting going. Thank you.
All right, you guys are. Oh, I'm sorry. I think I turned it off.
Thank you very much. Maybe. There we go. Thank you. Can you hear me?
No.
Nope.
There we go. Good evening, everybody. Welcome. Tonight is going to be a continuation of the conversation we had at our last meeting, and we have a number of individuals that are going to be presenting with us here this evening, and they're up here on the screen for you, but we have two individuals from our legal team, and starting at the end, we have Mr. Corey Huffman and Ms. Kathy DePay-Bruno. They are going to be here to talk about sharing some information that was a request from the Curriculum Advisory. And then we have Ms. Lori Houchin. She is the Director of Middle School Curriculum, Dr. Bethany Quisenberry, Director of Elementary Curriculum, and Candace Oliveto, Director of Secondary Curriculum for High School. So those individuals will be presenting along with myself tonight. Move to the next slide. So tonight we're going to talk about two items that we spoke about last time. And remember, this is not about a policy. We're talking about procedures within policy we're going to be talking about this evening, which is the same thing we talked about last time. The first one is the purchasing of library materials, or as it says up there, the management of library materials, which is really the purchasing of library materials. We're going to talk about that. And to refresh your memory, last meeting we came, you had the Post-it notes, we had you do the individual thinking, we put them on chart paper, collected them to find some commonalities, and worked our way through those Post-it notes. Those were the purchasing of the library materials. So we're going to be coming back to you this evening to either get your support or non-support of that process document. The other piece we're going to talk about tonight was a piece that you requested, which is going into the objection to the instructional materials, which is some people call the book challenge process. You asked for information on the Miller test. And how does the Miller test really fit into the challenge book process? So the informational component of that will be provided by our legal team, but it is embedded in the process of the objection to instructional materials. So those are the two topics that we're going to be talking about tonight. And now I'll turn it over to Ms. Oliveto, who's going to start us off. Just a refresher on the process itself, and then digging a little bit deeper into it. Candace?
Thank you. So inside your folders, you have a copy of the process document in which we discussed last time. It's also up on the screen. And this is just a high-level overview of the steps that are taken in which a community member or parent guardian can submit a challenge to materials. So if it is a parent within our schools, they can submit that directly to the school itself. And then if it's not resolved, it comes to the curriculum and instruction department. If it's a community member, that challenge can go directly to the curriculum and instruction department. Step 3 that's on here, this was the new piece, which is why it's outlined in this box. This discussed upon receipt of that challenge material, a parental consent form. Now, as you're going to hear later on from our attorneys, this may, based upon legislation, not be up for conversation based upon things we see coming down. So, but that was a new component. The next part of this here, though, is scheduling the ad hoc committee within 10 days. So the curriculum directors, if we can't resolve the challenge, schedule the ad hoc committee. Step 5 is what we're really going to discuss because as you heard Dr. Spiro say, the Miller test is embedded within there. So we're really going to hone in on step 5 here and who's part of that committee. But for you to be able to see, that committee is made up of a diverse group of individuals. You have the directors of curriculum based upon the level in which the book is being challenged. So if the book is only being challenged from high school, it's only in our high schools, it would have the director of high school curriculum and instruction. If it's all 3 levels, then all 3 directors are there. We also have content area coordinators. So we have specialists who are experts in that field. So there's an ELA coordinator who's always in attendance, but then also if it's a social studies text, we would have a social studies expert in that room there. We have our district-based media specialist, school-based media specialist, a representative from this committee, thank you all who sat and helped on those last year. We also have a member from Equity and Diversity, and then representation from the District Advisory Committee. Much like the directors of curriculum, if it's a book that's being challenged across multiple levels, then we have parent representation across multiple levels from DAC as well. So those pieces are there. That committee, I'm going to go ahead and walk through that because now this is where all the steps come into play. So that's who makes up the committee. Their task at hand is to review the challenge that's being presented in front of them. But there are some very specific pieces in which they have to consider, all of which are up on the screen for you, but they're also in the process document. As we had mentioned last time, that 3rd bullet is one that I want to point you to because this is one of the adjustments that we had seen come down from the Florida Department of Education, is that professional peer review sites. They provide very specific sites that they recommend districts utilizing during their challenge processes there. We're also looking at that content appropriateness, the reading level, the developmental level, that's there. In addition to the state statutes. So here is specifically where that Miller test is embedded, is within these state statutes. And that's where our attorneys are going to go much further in detail. Additionally, we look at the theme and the intended use of the material. So what is the purpose of that material? Does it tie to one of our courses? Especially this is where advanced coursework comes into play. These pieces are all taken into consideration. So ad hoc committee is convened. Everybody receives a book. They're all responsible for reading that book independently, reviewing for each of these pieces here. And then step 3 is a meeting is actually scheduled. Based upon how many challenges there are, depends upon how often the committee meets. What is currently inside of policy is as needed. For last year, for reference, the committee was meeting once a month. Towards the end of the year, it met every other week because it was important that these recommendations were being rendered by the committee there. During that committee, when everybody comes together, this is where the conversation really happens. This is where the group comes to consensus to make a recommendation. So all of those pieces that were just discussed in step 2, we also add to it any additional notes that are important. How long has the book been in circulation? How many times has it been checked out in the schools? So think about going back to our meeting last time where we talk about our reading of materials. If a book has not been circulated and checked out, that comes here, the publication date of it. Any published reviews that we have on file. Any awards that it has won, and then appearances on national and international assessments as well, because those are pieces that need to be considered when we talk about instructional purposes. So during that time, this is where we're gonna go a little bit deeper into the Miller test and some of those pieces that are part of the discussion. So I'm gonna turn it over to Mr. Corey Hoffman, who's gonna walk us through that step.
Thank you. Right, it's actually gonna be Kathy Dupree Bruno first.
Oh, sorry about that, Kathy.
I mean, I changed a couple of things. So Kathy Dupree Bruno, I'm the school board attorney and the general counsel for the district. And I would like to know, how many of you are actually familiar with the Miller test?
I've read it.
You've read it, okay. So why do you think that we actually have the Miller test? Where is it coming from? What's the source?
Well, part of it came from lawsuits, but it, you know, I mean, it's just like any other thing that comes up, you know, there was, something occurred and it had to be created, so it was out of need.
Out of need. So I'm gonna give you a hint, just look at the board here for the next question. Is there a particular constitutional provision that would apply? Which one?
Oh, that one.
That one.
The First Amendment. And what part of the First Amendment?
Freedom of speech.
Freedom of speech. This is what we're all talking about. It's about freedom of speech and when can the government intervene and say that this speech is not applicable or that you don't have this particular right. And that's what the Miller test is talking about. It's talking about obscenity and the right to be able to have free speech, which is a constitutional right pursuant to the First Amendment of the United States Constitution. So obscenity in the Miller test. This is a case that came out of California. It's called Miller versus California. It is a Supreme Court case that came out in 1973. And that was a pornography case. And basically the question that the court answered is, how do I figure out when that First Amendment right can be abridged? And one of the things the court said is that you do not have a right to espouse obscenities, okay? Now, how do I determine whether something is obscene? That is what the Miller test is. We call it a legal test. Basically, the court is saying, here are 3 factors that we want you to consider when you're making that determination. The first is whether or not it appeals to a prurient interest when taken as a whole. Does anybody know what prurient means? Is it, per Webster's dictionary, something that is marked by or arousing an immoral or wholesome interest or desire? Prurient, having or encouraging excessive interest in sexual matters. That's what prurient means. So does this appeal to a prurient interest? Excessive. 2, involves patently offensive sexual conducts. And 3, contains no literary, artistic, political, or scientific value. And last time I was here, the reason that this even came up is because of a discussion. How do you figure out what is a literary value? What has literary value? So we're going to talk a little bit about that as well. So the first problem, let's look at that a little bit more carefully. Whether the average person applying contemporary adult community standards finds that the matter taken as a whole appeals to prurient interest. What strikes you in that first prong? 6. So raise your hand so I can call on you. Taken as, someone said, I heard it, someone said something about average person.
Average.
Wasn't me, but I'll take credit for it.
Average person, okay? So whether the average person, and what else is really important in this particular prong?
And point of order real quick, just for record, the focus is on the members in the advisory. So we'll just ask, I understand, look, I love hearing people answer questions. I'm a teacher, so I get it. But just like kind of focus on allowing us to kind of.
So if we can raise our hand, that would be really helpful to me. So what else do you see in this first prong? Yes?
To me, as a whole, because you can always take a small portion of something and define the whole thing by it, and it would be really easy to take a small portion of a book and say, well, this part's obscene, but if you look at the whole book, You can do that with many books. I mean, you can, even in the Bible, there's parts in there that if you took one part of it, it would be considered obscene.
So average person, taken as a whole, and there's one other thing that's really important. Yes, ma'am?
I'm not answering the question, but I was curious if we could move that off the screen so you can see what the definition actually says.
Yeah, minimize.
Move it to the top.
Yay.
Yep, yes.
Contemporary, as in it's 2023 now.
Applying contemporary adult community standards. Average person applying contemporary adult community standards as a whole. So that's the first prong. Second prong, whether the average person, here we go again, average person, applying contemporary adult community standards finds that the matter depicts or describes sexual conduct in a patently offensive way. What do you pick up there? Average person again. What else? It's very similar to the first one.
Patently offensive
Oh.
and contemporary.
Adult, contemporary adult community standards. And patently offensive, right? And we're talking about things that describe sexual conduct in a patently offensive way. So that's prong number 2, the Miller test. Number 3, whether a reasonable person finds that the matter taken as a whole lacks serious literary, artistic, or political or scientific value. What does that mean?
It means a person, it has to be a reasonable person. It can't be somebody who is unreasonable or has a certain agenda or is not a stable person.
So a reasonable person, I think we're talking again about that average person, but a reasonable person is a legal test that you'll find throughout the law. It's called a reasonable person standard, and that's what this is talking about. And each area of the law will define what that reasonable person is, and we're gonna talk about that. Mr. Montrose, you
I
have
was just gonna add just good faith. But you were going to explain it, so I'll defer to you.
And then this whole thing about lacks serious literary, artistic, political, or scientific value. What does that mean? Or is that why you have us here today?
In other words, it's not simply for gratification.
That's a good point. Yep. Anybody else have any thoughts about what that means?
I
Yes.
think it means that it can it doesn't have to cover just one aspect. It can cover one part of that. It can have a scientific value, but someone could have something in it that they may consider to be obscene. I mean, if you're gonna have a scientific value and it's covering something that has to do with, sex, somebody could say that that wouldn't follow the standard, but it would have a value that would succeed over that particular issue. So, or, you could have somebody that, I'm not particularly artistic. You could show me a book that's artistic. To me, it might not have value because I'm not an artistic person, but to somebody else, it would have value.
Good point. Very good point. So hold that thought in terms of what that means, and we're gonna have a little bit of a discussion on that. So I'm going to point out a case. This Pope versus Illinois is also a United States Supreme Court case. It came out in 1987. And this case says, the mere fact that only a minority of a population may believe a work has serious value and is therefore not obscene does not mean the reasonable person standard would not be met. Okay? So keep that in the back of your mind as well. So let's really figure out, what does this reasonable person standard mean? The court has defined that in Pope versus Illinois again. This is a 1987 United States Supreme Court case. Reasonable person looks at the community standards. What's your average person in your community thinking about this particular item, material, book, what have you, piece of art, what have you? The community standard was developed to assure that obscenity evaluations were made on the basis of the average person applying contemporary standards. Its primary function is to protect First Amendment values by guaranteeing that a juror will not indulge his or her own personal and private views and resolving the obscenity definition. Does that make sense? Yes, ma'am.
The community standard was developed to ensure that obscenity evaluations were made. What kind of evaluations?
Excellent question. So pin that thought too, because that's gonna go back to our conversation about literary, artistic value on books and all that stuff. So those two go hand in hand. Excellent question. Under a community standard, the juror must draw on knowledge of the characteristics and differing attitudes in his or her community and deciding what the average person applying contemporary community standards would reach. So this takes me back to what Ms. Oliveto just talked about in terms of our ad hoc committee. As Dr. Spiro said, the Miller test is embedded in our process. So when you're looking at this ad hoc committee, it's having individuals who will be able to provide the knowledge as well as the feedback to determine what that reasonable average person would think on this particular book. So in that committee, you're going to have your school-based administrator, you're gonna have your media specialist, your curriculum content coordinator, the person who's saying if this is a social studies book, how valuable it is. If this is a English book, how valuable it is. You're gonna have your curriculum level director, you're gonna have a member of this committee, and you're also gonna have a member of your equity and diversity committee. Those individuals in that committee are trying to help figure out what would a reasonable person think about this piece of work and go through that Miller test. When you're going to court, when we have these court challenges, one of the things that the judge is looking at is whether or not you applied that test, whether or not you had some members of the community, sometimes as experts, that come in and help provide evidence for the court to be able to consider whether or not these tests have been met. It can't just be the judge making that decision. They rely on the evidence presented. And this ad hoc committee and their analysis in the process, they're actually looking at the evidence, and we'll talk a little bit more about that, because that is how you make that value judgment. Does that make sense? Questions on that?
I'll throw one out.
Yes?
So if the school board, school administrators, teachers, librarians, media specialists, and everything, have already in the past approved of a particular piece of literature, okay, and they're set, there's not any changing of a mind there because it's already been evaluated, approved, and it comes before an ad hoc committee. You're putting people in the room who already have a predetermined point of view on that piece of literature, maybe versus one or two other people who had an interest in seeing that sway. So when we're talking about standards, you know, ultimately, I think we're gonna have to define standard now. You know, because as far as I'm concerned, there is one standard. I don't think a standard changes from community to community, okay? There is a right and there is a wrong. There is truth, there is fiction.
That's not
Up,
necessarily
down.
true. Your
Point of
right
order,
is not
Mr.
my
Chairman.
right.
Point of order,
Yeah,
Mr. Chairman.
allow Mark to finish and then
Okay,
you
sorry.
can go ahead.
There's gravity, I jump off a building, I'm gonna fall. I mean, there's certain standards in this world that we just cannot escape. So now we have to figure out whether or not somebody coming in and challenging a standard is going to be taken seriously because they feel like they're reasonable as well. And they believe that they have a voice that can be heard as well. But that decision may have already been made before they came in. Again, because as I've mentioned, if it's already been pre-approved, is that standard even going to be challenged if nobody's really willing to take into consideration another point of view?
So that's an excellent question, and I think it's a very fair question. Because what is supposed to happen is in this committee, they're not supposed to be preconceived notions or preconceived thoughts. The individuals who are there are most likely not the ones who have actually purchased the book. They're the ones who should be able to come in there with a clean slate and actually review the material, read the material from front to back, and have the discussion. And we're gonna talk about some of those factors that need to be considered. So I think your point is well taken. It has to be, to make sure that this committee operates properly, it has to be those that do not have a preconceived notion. Because really, the committee is acting like a judge. And a judge should not have a preconceived notion about a case. It's supposed to sit down, listen to the evidence, and then make a ruling based on what is heard.
And then in the process, just remember that a committee member shall not be selected from the school where the challenge in the materials originated, so that we don't have bias.
And Cheryl, you can go ahead.
Isn't that really just circulating back to being a reasonable person? I mean, when he talks about a standard and right and wrong and for, this, that, and the other, isn't that still a reasonable person in the Miller Rule? Because what he considers right might not be my right. It might not be somebody else's right, and that's why it has to be the reasonable person, the average. So when you're talking about what somebody says, well, this is right, well, that's right for them, but it might not be right for me, it might not be right for her or for somebody else. So there is no true wrong, right in some cases.
So that's another good point, and I'm gonna go back to what you said, Mr. Gillespie, because the courts there are 3 prongs, right? But the court says the first and the second prong, you gotta look at your community. It's a community standard. And the court's very clear, it can't be just one particular group in your community. You have to really hear and represent what the average person, the reasonable person standard in your community, what they're saying. So it can't be this, it can't be that, it kind of has to be the reasonableness, and that's why you have all those people on your committee to be able to hash that out. Second, the last prong, which is talking about the literary value, the court actually says this is a national standard. So we're going to talk a little bit about that as well.
So a quick question on community. So in the case of with the book challenges, would the community be considered the constituents of the school district, students, teachers, parents? Is that the community? Or
All
are
of
we
it.
talking about Fort Myers who don't have kids in school? I mean, what are we?
All of it,
Okay.
all of it. You're a community in Lee County, made up of those who do not have kids in the system, made up of those who have children, who are your teachers and your media specialists, who are your parents. All of it is going to help you determine what that reasonable person standard is. Yes.
And I might be wrong in saying this, but didn't Pope versus Illinois also say that it doesn't necessarily have to be the majority of the people?
Yes.
Okay.
Okay, so now we're going to go to the next slide, which talks about that national versus local standard. So Miller argued that there should be a national obscenity standard, not one based on local community standards. But the court disagreed, and the court said, and I'm going to quote, "It is neither realistic nor constitutionally sound to read the First Amendment as requiring that the people of Maine or Mississippi accept public depiction of conduct found tolerable in Las Vegas and New York City." So that's why the community standard in Lee County is what you're going to be applying versus the community standard in Jacksonville or Miami-Dade or Polk or Leon, etc. Okay, so that's really, really important. And where do you get that community standard? From the people in your community, from your school district, from the parents who are serving or individuals serving on these board advisory committees. That's where you're going to get that from. Any questions on that? Pope also said that the trier of fact should apply the national standard for the third prong, like I was telling you, which is the literary artistic value. All right, another case I wanted to go through, which is the Pico case. This is also another United States Supreme Court case from 1982. And the court says, "We are concerned in this case with the suppression of ideas. Today only affects the discretion to remove books. In brief, we hold that local school boards may not remove books from school library shelves simply because they dislike the ideas contained in those books and seek by their removal to prescribe what shall be orthodox in politics, nationalism, religion, or other matters of opinion." So this is a really important case, because this case actually talks about the removal of books in schools, and that you have to go through the Miller test. The only way to be able to sustain your objection is to go through those three-pronged tests, that if challenged, you can say that I went through the three-pronged test, I did my reasonable person standard, and this is what my ad hoc committee made the recommendation for. And then the school board, if they decide to remove a book, has to be able to be prepared to be able to defend, should it be sued, about how this process took place. It's all about process, which is embedded, as Dr. Spira said, in your process document. Questions on that? There was a very recent case, and I won't go through too much in it, but there was a recent case in Texas. It's a little different than schools, because this was just a public library, which has a little bit of a different standard. But they removed books, and this just came out in March of 2023. And very recently, the court said all these books have to be put back into the library. Again, First Amendment rights, and in that case, there was also some 14th Amendment concerns. That case is still proceeding, so I don't want to go too much into that case. But just to let you know that the courts do look at this very, very seriously. So that's why it's so important for the school board to make sure that these processes and legal tests, what we call the legal test, the Miller test, is applied properly. Because no matter what decision is made, the book stays, the book goes, someone doesn't like it and they file suit, it is the school board that will have to defend. And part of that defense is to make sure that these processes are followed and these tests are done correctly.
I mean, it's hard for me to wrap my head around the third prong sometimes. You know, a book, I've read a book that had relative literary value.
Brian, could you speak up a little? I'm sorry.
Sure.
Sorry, I've got allergies, my ears are a little buzzed.
But the third prong of the Miller test, so a couple pages were, can a book given to minors ever be child pornography or some kind of peddling of, you know, even though the book was mostly good, there was a few pages where it's inappropriate, to say the least, a little creepy, that adults are providing these to people under age 18. So that's where it's hard for me to wrap my head around. Can you delve into, I don't know, Florida state law or you know, where graphic sexual content is in a very small minority of the book, but it's there. Certainly, it would be a rated R movie if depicted on the screen, I would presume. But that's my general question.
Excellent question. So the first answer to your question is that when I read something, I may find this to be acceptable to my 13-year-old. Ms. Hutchin may read something and she said, nope, this is absolutely not appropriate for my 13-year-old. And that's, again, why you go through this reasonable person standard, where you have this committee that's doing an evaluation together, having discussions, listening to the information that's being provided, to be able to make that determination in terms of, in my community, what is that standard? So that's a very good point, and we're going to talk a little bit more on another part of your question. So what does the Florida statute say about this? So we've been talking about the Miller test. 847.001 is a definition section. This is actually a criminal code, and this is the one that talks about harm to minors, okay? Before we usually read a statute, we want to make sure that we understand what the legislature's definition is of that particular, some of the words in that statute. So 847.001 defines obscene in Florida statute. Means the average person applying contemporary community standards would find, taken as a whole, appeals to the prurient interest. 2, depicts or describes in a patently offensive way sexual conduct as specifically defined herein, and the statute does define certain sexual acts and sexual conduct. And C, taken as a whole, lacks serious literary, artistic, political, or scientific value. Where have you heard that before?
Almost word for word.
That's word for word the Miller test, and it's codified in Florida statute under the definition of obscene. Now, harmful to minors, again, the definition section of Florida statute 847.001. Harmful to minors means any reproduction, imitation, characterization, description, exhibition, presentation, representation of whatever kind of form depicting nudity, sexual conduct, or sexual excitement when it predominantly appeals to a prurient, shameful, or morbid interest, is patently offensive to prevailing standards in the adult community as a whole with respect to what is suitable material or conduct for minors, and taken as a whole is without serious literary, artistic, political, or scientific value for minors. Where did we hear that before? Again, the Miller test. This is Florida statute. This is what specifically is codified in the definition when we're talking about obscene and where we're talking about harmful to minors. Questions on that?
I have a question. There's a case, CKB Wentzville School District from August 2022, that the judge states, in this case, it was a minor suing, a parents on behalf of a minor suing their school district for removing books. And the judge said that it is not clear that PICO is binding in this case. And additionally, I have concerns that applying contemporary adult community standards when it comes to minors.
So I understand what you're saying. It's the United States Supreme Court case. PICO is the United States Supreme Court case. Ms. Merchant, can you tell me that citation one more time, please?
The case?
Yes, please.
CK v. Wentzville School District.
What district?
I can email it to you. I have it on my phone. WENTZVILLE School District.
By any chance, do you have the numbers affiliated with that? Do you know what state it is?
Oh,
Missouri.
Missouri.
Missouri, okay, thank you very much.
I thought I gave this to you because you were worried
It's
about
quite
what I was
possible.
handing to you.
That's quite possible. So, and I will say this, courts interpret law, and they take the facts, and then they make a decision. And I can understand where Ms. Merchant is coming from in terms of the application of PICO. A lot of times it's case by case, fact by fact. So I don't have anything specifically from Florida, that's Missouri, so Lori's looking at it right now, and we'll be able to address that. But I will say, I understand what you're saying, but I'm still stuck with the Florida statute that says the same thing.
I understand. So, to follow up, PICO, if I remember correctly, because it's been a while since I've actually read that case, it garnished 7 different opinions. There was no majority opinion, right? So what happens when there's no majority opinion given in a Supreme Court case? Nothing?
So PICO, what we pulled out from PICO that we shared with you was with regards to the removal of books. I'm not saying that you're not going to have a case like, for example, what happened in Texas. They actually removed books. So I'm not saying that you will not have a case where the judge will say, I agree that this book has reached that level that it needed to be removed, and school board, I disagree with you, I agree with the parents, or school board, I agree with you and disagree with parents. That can happen anytime, right? That's why we have this legal system. What I'm providing to you is what the law says, so you have a better understanding of how its application is applied to our current processes. You can always have a case where they pull a book. Does that make sense? I'm not disagreeing with you on that.
It's Monday after a long 10-hour workday. I'm barely processing.
I'm with you. Yes.
Yeah, I just want to, just to piggyback off that, just noticing in the language of the case, that basically they were challenging the district's ability to remove materials and quote, because of the ideological disagreement members of the district school board and certain vocal community members have with the ideas and viewpoints that the books express. And I take the challenge process as a way to prevent that from happening.
Again, excellent point, because that is exactly why we have a challenge process. And that's why I said what I said before. The work that that committee does on behalf of the school board to make the recommendation to the administration as to whether to keep or not keep a book is extremely important should this become a legal action. So very, very good point, yes.
And you could say too that with that particular case in Missouri, that their community would not be the same as our community.
Absolutely. Yeah, so again, you have to look at what and those two prongs, local community, you have to look at what your local community says. And that's gonna go vary from county to county. Yes?
And I'm just gonna kind of double off of that because I keep hearing it sounds like we're kind of repeating the same thing that's already been said. It really does boil down, and maybe you can correct me if I'm wrong, it boils down to the layout of the community to decide who the ad hoc committee is, as long as it is a clear representation of every facet of the demographic in that community. So, I mean, because I know we're getting clarity, but it's just basically, it's really how the community is designed. If it's designed for Missouri and the county in Missouri, that may work for them, but it doesn't necessarily work for Lee County. And so, am I correct on that?
Absolutely, that's exactly what the court said, and that's what the process is. And I'm gonna add one other, because I'm an attorney, but attorneys are attorneys and counselors of law, so I'm gonna add one little more piece. The community is not, although it feels like we are very, very far apart in our thoughts, but you're not. Because one group is basically saying, I'm concerned about students, and I'm concerned of what they're exposed to and how that exposure is affecting them. And I don't agree with some of these things, and I think it's going to have a bad effect on them. You have another group that's basically saying, I want the kids to be exposed as much as possible because it's good for them and their critical thinking and their analysis to encourage the joy of reading, to have that exposure. Everything's about the kids. So you're really not that far apart, and that's why you're looking at that reasonable person standard to try to find what's the average Joe going to say about this, not on this side, not on this side, but taking everything into account, keeping the student in the focus, as the focal point, how to resolve this particular, and that's what you're doing, that analysis. Okay? And I have more to go back to Mr. DeGrazio's point on literary, and I know Mr. Gillespie, you asked a little bit more on that too, so I have a little bit more to talk about regarding how do you figure out that literary value.
Just
Yes.
one more follow-up. It says, you said that chapter 847 is a criminal code. Is there anything in the education code that targets this?
So there's some legislation. We do have the bills that came out last year, which is why we're even talking about 1467, and there's some other bills that arguably are related, and there's some new bills that are coming. So yes, in the legislative code, the educational code, you're gonna find some things, but to define obscenity and what is really important that 1467 and some of the others talk about, which is Florida Statute 847.012, that's where you're going to find it. So 847.012, which is built into your process document again. This is about, section 3 of that code is talking about a person that knowingly selling or loaning for monetary consideration anything like a picture, a book, pamphlet that really was talking about obscenity, primarily very close to pornography, but sexual excitement, sexual conduct, etc. 847, to your point, Ms. Merchant, 847.012 subsection 5 is the one that's really applicable to students in the educational setting. That's the one that says An adult may not knowingly distribute to a minor on school property or post on school property any material described in subsection 3, which was what we showed you before. As used in this subsection, the term school property means the grounds or facility of any kindergarten, elementary school, middle school, junior high school, or secondary school, whether public or non-public. This subsection, and this is really, really important, because this is part of your analysis. This subsection does not apply to distributing or posting of school-approved instructional materials that by design serve as a major tool for assisting instruction of a subject or course by school officers, etc. Part of your contemplation. Now, a lot of the things that the ad hoc committee is not necessarily looking at instructional materials. There's a process for that. You're looking more at your school libraries and your, at some point perhaps when we talk about the legislative update, it could be your classroom library, but still concepts, still similar concept. Questions on that? Now, so what does this mean in terms of how I figure out this literary value? I want you to look at, again, process steps 2 and 3 that we talked about. You know why you have this ad hoc committee. That ad hoc committee is standing as your reasonable person standard, because all of these individuals with different backgrounds, different thoughts, different ideas are coming together to try to represent the community, and then you're going through this Miller test analysis. So what are you utilizing? You're looking, well, first of all, what's my first prong in the Miller test? Prurient interest. So you're looking to see, is this free from pornography? Is this a violation of 847.012? You're looking at the second prong, you're looking at the third prong for literary value. What's the theme? How are we going to use this material? Is it the only book that talks about whaling in New Zealand? Does it have some value because it's the only one? That's something to consider. What have other individuals thought about this book? Such as, has it won any awards? Did anybody else find it to have merit that's associated with the title? What about reviews? What are other authors, publishers, school districts, educational professionals saying about this book? That should be all part of your discussion and your analysis in the review challenge committee. What are people saying? How is this relative? How are people looking at it? When was it published? Is this, a new book, an old book? Has it tested the test of time? Have we had these discussions before? These are all things that you should be thinking. There's no right or wrong answer. It's when the committee gets together and goes through its process and thinks it through and comes up with a resolution. That's how you do it. That's how you apply the Miller test. Any questions? All right, so at this point,
it's okay, you can keep driving, because I'm going to hand it right back to you. So, Kathy did a great job of reviewing, coming back around to how we embed the Miller test and all of those other pieces into our committee. And so step 4 is that after all of those discussions, the ad hoc committee then, using an interest-based process, comes to consensus. So it's really important that we remember that it's not a voting majority committee, it's interest-based. And so we all come to consensus inside of that committee. And decide on the recommendations. So the recommendations are on the screen. Continued use of challenged materials in instructional and media circulation, or use for media circulation only, or use for instructional purposes only, which we see often in, as Ms. Holiday talked earlier about, in our advanced courses, or use the challenged material with the following guidelines, and then the ad hoc committee has discussions of what are those guidelines that we need to put into place with these with the particular book that we're reviewing. Or discontinue use of challenged material during instruction and remove from media circulation. So we then take those pieces of the process and we send them, you guys have the process document in front of you, but then it goes through a couple of other steps to the superintendent and to the board. And now I'm going to turn it back over to Corey.
Thank you. So before we go to Corey, what Dr. Quisenberry said in terms of consensus. What Dr. Quisenberry said with regards to consensus is really, really important. And I think that I really want to drive that point, because this is not a process where, okay, we read the book, now everybody vote, do you like it, do you not like it? Consensus means that we're having some pretty significant discussions to see where everybody is. Well, what do you not like about this? What do you not like about this? This makes it a completely different process than a simple vote yay or nay. Okay.
Thank you, Kathy. And I get to discuss with you some pending legislation that may kind of change this process as we go through. So I'm going to talk to you specifically about two bills that are making their way through the legislature. House Bill 1069 and Senate Bill 1320. You're going to see that I've got a few slides where I'm talking about both of them because this is language where they overlap. And then there's going to be a couple slides where I'm talking about one specifically where they might not overlap. And the reason that's important is because before a bill can get before the governor, both the Senate and the House both have to agree on specific language in a bill that they're going to present for the governor to sign. So as of right now, House Bill 1069, which is going to be the biggest portion of this presentation, has already passed the House and has been presented to the Senate. But the Senate Bill 1320 is currently going through the Senate's committees. And it does have a little bit different language, and so we'll have to see what the Senate ultimately ends up doing, if it ends up following some of the language in the House bill, or if they're going to try to push back to the House their language of the bill that they would like the House to reconsider before it goes before the governor. Does anybody have any questions about that before I proceed? No? Great. So first of all, we're talking about that objection form. So what starts this whole process is when there's a piece of literature or proposed literature that's already in our instructional materials or in our media centers and a parent wants to object. This is the objection form that is being referred to here. So the new language in the bill adds that objection form that is prescribed by State Board of Education rule, which will be promulgated after this gets passed and signed into law. And the district's school board's process, which is what they require us to then create once these bills get passed, must be easy to read and understand and be easily accessible on the homepage of the school district's website. The objection form must also identify the school district's point of contact and contact information for the submission of an objection. And I want to note, this is almost identical in both bills, except in the Senate bill, that last sentence there, that the objection form must also identify the school district point of contact and contact information, is not currently in the Senate bill. The rest of it is, but this is the proposed language from the House bill. Another addition in both of these bills, and this is verbatim in both bills, is it adds another prong to 1006.40, which you may remember was on like slide 7 earlier in this presentation, which is what has to be considered when a school is purchasing books and utilizing the funds that it has to purchase instructional materials. And this specifically adds that outside of it not including pornography, which is what currently is in that list, it also adds that it depicts or describes sexual conduct as defined in statute 847.001 subsection 19, unless such materials is for a course required by these various statutes, which generally includes health, life skills, and other similar necessary courses that they believe, where that literary value, scientific value discussion kind of comes from, Are we going to continue to allow even the sexual conduct to be in the book because there's other value in this that these students need to learn as part of their curriculum. Go ahead.
Just noting the last part, identified by State Board of Education rule. That seems pretty, like, does that basically give the Board of Education kind of an end around to work around the Miller test?
No,
Okay.
because the Miller test is a Supreme Court decision, right?
Well,
That
yes,
everything has to go through. I mean, it potentially could, but I mean, anything can be challenged, anything can be created and potentially challenged. So,
Well, this,
but what this does is it gives more guidance on when we're including certain instructional materials, yes.
no, I mean, the first sentence seems to be a workaround, no? I mean, wouldn't that, because it was the third prong of the Miller test that allowed so many of these books to go through during the ad hoc committees, you know? So is this now,
So, yes, good question. So, yes, you're right. Does this make it a little bit more explicit? It absolutely does make it more explicit. Now, but remember what it also says is unless such material is for course required by 1003.46, which is gonna be your health, 1003.42 subsection 2N, which is a lot of the life skills, and then 1003.42, I haven't memorized that one, but I believe it's also part of the life skills. So, yes, it does, but does it, can there be exceptions? Absolutely.
no, absolutely, I mean, I think most people that have objections to some of this material would be fine with health courses being a bit explicit, so this would, I could see it be a challenge, but this would be it. So, in our ad hoc committees now, these books that didn't pass, you know, that third prong of the Miller test, they could now be held up. Is that what your, you know, is that your general view?
Are these just instructional books or are these all texts?
So first, let me put a big caveat out there. These are proposed legislation. Pass, quite possibly could pass. But I want to make sure that everybody understands this is not law just yet. That's one. Two, when we get new legislation, one of the things that legal does for the district is examine, analyze, and evaluate that legislation. Part of that is going to be reading the analysis from the Senate and the House in terms of what their interpretation and what their thoughts were. We're not there to be able to do that yet. At some point we will be, but we're not quite there because these bills have not passed.
And I just got a quick question. I think the last meeting we had, there was a discussion that there was an actual book that has been banned here in Lee County. Am I correct on that or incorrect?
One of them.
Was the Miller test applied in that decision? And can you guys just give us an example of what that looked like in that process, if you're able to?
So the book that we removed was deemed to have, it was objectifying a sex, and there was no literary or scientific merit. So it did not appear on any advanced placement test or anything like that. And it just didn't pass the third prong according to the committee.
Was that like unanimous agreement with the committee?
It's
or-
consensus.
Okay.
I don't recall any thumbs down on, yeah.
May I ask what book it was?
It's a long title.
Fly on the Wall, How One Girl Saw Everything.
Okay, thank you.
You're welcome.
I'm sorry, I just gotta circle back to that, to the State Board of Education rule. I'm concerned that what this provides is the State Board of Education, which is a political board, very partisan, I might add, the leeway to define sexual conduct.
See, that's not what that's saying here specifically. It says, unless such material is for a course required by these Florida statutes or identified by State Board of Education rule. Meaning that the State Board of Education is determining what courses that is going to, such material should be included in. That's what this is specifically stating. Not that the State Board of Education gets to define sexual conduct. Sexual conduct is as defined in Florida statute 847.001 subsection 19. So that definition will not change unless the Florida legislature and the governor pass a law that changes that definition.
So this is basically just saying where it is appropriate, not where it's not appropriate.
Correct. I mean, and even Kathy and I had a very long discussion as to what the implications of this is. So, I mean, there's always going to be disagreement, and I think both of us would agree that there is a potential workaround. Because this is very clearly the second prong, right? To anybody that's reading this, this is the second prong. So they're saying we don't want, if it meets the second prong. I think they're trying to utilize these statutes as to what are material for specific courses as kind of going into that third prong. They're kind of trying to say, we've already decided that if it's part of this course, it has this literary, artistic, or scientific value. So you're giving the third prong here. You can make that argument, whether or not a court later on, if this is ever challenged, if it passes first, then if it's applied, and then if it's challenged, will the court agree that the Miller test is fully met here? I don't know.
I just have two quick questions. So from a legislative point of view, they're elected officials,
Yeah.
so they represent the community. So I would argue that whatever comes out of Tallahassee also represents community standards, because we put them in office. We voted them in. And then the second part of that is, I'm a little concerned that this hasn't even started yet, but we're already looking at workarounds. Yeah. And that's been my problem.
What do you mean by this, we're looking at workarounds?
Well, you just said, there might be a workaround.
I
Yeah.
think you
No,
answered the question that was posed.
The question was, is this statute,
Okay.
is this statute a workaround for the Miller test? And I said, Kathy and I actually disagreed on that ourselves as legal minds. Legal minds are going to differ in a lot of different ways. I mean, and that's why we have different courts and different levels of courts. And even as Ms. Merchant said earlier today, in the Pico case, that split the court quite a bit, because even on that large body, the largest body, the ultimate decision maker for our country, even their opinions are going to differ. So do I think that this is ultimately a workaround by the legislature to get around a Supreme Court test? I don't know. Because I can definitely see that this is prong two.
I misunderstood you, I'm
Yes,
sorry.
and I can also see where they're trying to apply the third prong. They're just trying to get ahead of it, right? They're not trying to take it back. Does that make sense?
Can I say something about, as far as the representation of who's in office? That doesn't necessarily represent the community as a whole. You have a lot of people who aren't registered to vote. You have kids that aren't registered. They also represent those people. And you have also within the, I think it was Pope versus Illinois, that not necessarily the majority is what wins. You have to consider everybody. So you're not talking about just because everybody who is the majority agrees with it, you still have to represent everybody, even if it's a small portion. But our legislators don't necessarily represent everyone. I can tell you that, I work for
We
the
are-
legislature.
Point of order,
Point of interest, it's impossible to please everyone.
Hey, point of order.
I will just,
We have established that there is a political disagreement on the issue. All sides have been represented and heard, so can you please continue?
yes, and I'm gonna end this by specifically stating that if this bill gets passed, it is the law of the land in the state of Florida until someone tells us otherwise. And that is what this body, this school district is going to follow. The next section is library access. Both bills have this statement in here that each district school board shall adopt and publish on its website the process for a parent to limit his or her students' access to materials in the school or classroom library. Okay. Now, going more into just specifically what House Bill 1069 stated as opposed to Senate Bill. And there is some language that the Senate bill does address in here that I will get to, but it specifically talks about any objection under 1 and 2. So as I mentioned earlier, that we just had that nice heated discussion about, prong 2, depicts or describes, was added. In the Senate bill, it states that if there is an objection under 1 that is pornographic or prohibited under that Florida statute 847.012, which we briefly went over in a few slides ago, or 2, this new, if this gets passed, this new prong that's going to be added, if a parent objects saying that this material that is in our schools as one of these two prongs, then at that point in time, the book must be removed within 5 school days of receipt of an objection and remain unavailable to students until the objection is resolved. Now, the Senate bill doesn't say that specifically, but it does state also that the book must be made unavailable to students until the objection is resolved, but it doesn't give a specific time period. The Senate also has this next prong: this parent has the right to read passages that are subject to an objection. And that's during the process of that objection process where they're going to provide that evidence, right? Now lastly, this is only in the House bill, this is not in the Senate bill. If the school board denies the right to read passages due to the content meeting subparagraph 1, meaning that the school board is saying, I'm sorry, parent, you cannot read that out loud in this forum because I believe it's pornographic under this prong 1, then at that point in time, the school board must discontinue the use of that material. Like I said though, this is not currently in the Senate bill, so I want to point out those differences between this language that's in the House bill that has already been passed and the Senate bill that's currently going through the Senate. And then lastly, there's another layer of appeal for parents, right? In the Senate bill and in the House bill, it has this first top part, right? That meetings of the committee to resolve an objection must be noticed and open to the public. So both of these bills are stating that these meetings now must be noticed and open to the public, and that the committee must include parents of students who will have access to such material. So that's a change that's going to be made by that, to that committee that we talked about. Who is the membership? This bill would change that to include a parent of students who will have access to such material.
Is that only pertaining to parents who challenge a book and lose that challenge? Or does that pertain to a parent who actually may want the book to remain?
It says must include parents of students who will have access to such material. So it should be either, both, or however, the ad hoc committee decides what that membership looks like, who applies. There'll likely have to be processes that are created that determines who can apply to be a part of that committee, how they can show that their student will have access to that material. But that's processes that the State Board of Education usually promulgate after these bills are passed.
Corey, just to share as well, part of our current process is to have a member from the District Advisory Council, which is our parent, I'll turn my t-shirt close on, which is our parent representation. So our current process says that it's a book that's being challenged at all 3 levels. Then we would have a representative from the elementary DAC subgroup, the middle school DAC subgroup, and the high school DAC subgroup. So that is in our current process document as is.
However, this bill would codify that in Florida statutes if it's passed. Next, this part is only in House Bill 1069. And that creates an appeal process that if a parent disagrees with the determination that is made by the school board, they may request that the Commissioner of Education then appoint a special magistrate.
Question.
Yeah.
Does the bill include qualifications for the magistrate?
It does. It has to be an attorney that has at least 5 years of experience, and it has to go through a specific list. I didn't think to include that on that slide, but I think that's a great question. It does specifically lay out what the qualifications are. Okay. The special magistrate will then determine the facts relating to the school district's determination, consider information provided by the parent and the school district, and render a recommended decision to the State Board of Education within 30 days of the parent's request. It also states that the State Board of Education must then approve or reject the recommended decision no earlier than 7 days and no more than 30 days after the date of the recommended decision is transmitted. So ultimately, the State Board, under this new appeal process, would have the ultimate decision as to whether book one, was the school district's decision correct? Did the special magistrate make the right decision in its recommendation? The State Board of Education. Again, this is only in House Bill 1069. This language was not found in the Senate bill. And I'm going to hand it back over to Richard. Oh, we got a question. I'll start with Vanessa.
Once the decision has been made, when does it become final? As some people don't actually take no for an answer. I'm just curious, is it, at some point, if they find it, that the book is approved and it's good, is at that point a done deal, or can they come back in 6 months, 8 months, a year?
So, under the current system, if, where the book is being objected to and the ad hoc committee is making a decision and the school board approves the ad hoc committee's decision, then that is the final decision. There is an appeal process, of course, and this would be a separate appeals process for the special magistrate. In the state of Florida, everyone has due process rights and can appeal to the district court as well. But under this new proposed appeal process, then the decision would be made final once the State Board of Education approves it. It has to be placed on the State Board of Education's agenda, which is no earlier than 7 days and no more than 30 days. So they try to give very tight timelines when these have to be heard and decisions have to be made. And I believe I saw Ms. Merchant, did you have your hand up?
Yes, not specific about the bills, I guess, maybe more so than their sponsors during debate mentioned that in 2021, there were 23 districts in the state of Florida that had books removed or audited, or I can't remember what word they used specifically, and 84% of those books that were removed were due to pornography. And I am waiting on them to send me the information on that, but was Lee County part of the 23 counties that participated in that? I didn't think so, but I don't know. Okay.
I don't know the answer to that, but I'm sure we can look into that.
Okay.
Any other
I've
questions?
asked, but it's Tallahassee, they'll take 10 years to respond, so.
I'll hand it back over to Laura Hobson. Thank you.
So in the process document, as you recall, we had 3 parental permission forms. And one of them, where the arrow is pointing, is that while it was being challenged, if a parent wanted their child to check out the book, then they would sign a parent permission form. As you heard, if legislation passes on House Bill 1069, that would have to be revised because that book under law then would have to be removed within 5 days until it has resolved, and we would have to get clarification from legal as to resolved and not challenged again, or resolved and goes all the way to magistrate. So the timeline for that would have to be determined as to what resolved is.
I did have a question. This stems back from our last meeting. If a parent can ultimately put, as we discussed, that I don't want my kid to read books on hippos, or I don't want my kid to read certain types of books, why are they not also allowed to say my kid can read any books? It doesn't quite seem right that we can ban them from reading books, but we don't allow parents to allow their creative expression if they feel their child should be able to read these books.
So by virtue of you saying nothing, that's saying your child can read books, whatever books that they check out.
But they
It's
were-
when you, I'm sorry.
I'm sorry, honey. No, I did not mean to interrupt you.
Yeah, go ahead.
But we were told in the last meeting that parents could ban the types of books their children could read, the materials they didn't want them to read, but they were not allowed to put in where their child could read any books, meaning if I felt my child could get any book that was available to them, that I could not fill out a slip saying in the computer where it says, don't allow, don't allow, don't allow. There's nothing that says allow, and I don't understand.
So what I will say to that is just that the first instance is allowed, and then you start disallowing. So you guys want to add?
That's correct, and so there's only a note placed in Destiny restricting if a parent requests that it be restricted, or if the ad hoc committee made a restriction on that book. But otherwise, everything that's in the media center is available to a child unless a restriction was placed on a book or topic or author by that parent.
The other piece of that is, as we just went into detail with the Miller's test and other pieces of legislation, is if a book is challenged and the committee comes to the recommendation that it does not meet the Miller test and it is violating one of that statutes, we are legally required to not make that available for students. That's why we would not be able to say, yes, if you say so, you would have to have that parental right on your own at the public library, but if we deemed that it was violating a statute, we could not legally provide that for the students. Does that help? No?
I'm still a little confused, just because they were saying that a parent could not just allow any books to be taken out by their child. So from what you're saying, if it came to a point where the book was deemed inappropriate, it's going to be pulled from anyone anyway.
Correct.
But there are certain books that aren't allowed by children. I thought we were talking by ages and by material. And some parents would like their children to have access to any books. And they're not allowed to fill out a slip saying that.
There's also additional.
They're gonna get, it's about the phone call. If it's a certain book that there was something on it that you had to call the parent, get a permission slip. Some of the parents have expressed, we would like our child to be able to take that book out and not have that process where I have to.
That was in the guidelines for the challenge that was step 3 that we talked about. If this new legislation does go through, we would no longer do that because legislation would make us pull it until the ad hoc committee deemed it appropriate or gave those recommendations.
But that's if it passes. If it doesn't pass, it's still as she speaks of now.
Yeah.
Right, and that's what she's wanting to say, if it doesn't pass. Why is it that somebody can limit what my child reads where we can't say, well, your child gets to read everything, but you can limit what my child
So that's only in place until the ad hoc committee, because it goes back to my previous
Right.
statement, because the ad hoc committee has not yet reviewed that book to prove that it is not violating a statute. So when we get a challenge, that challenge is saying, this material is violating this statute and you are legally obligated to ensure that this is not available for minors. We have not reviewed that yet as a committee, and so in the meantime, we're telling families, hey, this has been a challenge, you can approve it. That's a way for them to still be able to check it out, but it's still ensuring that we are able to
But you really
not
only
violate
have
statute.
one book that's been removed.
That's correct.
And how many have been challenged?
34.
Okay.
And as Candace spoke earlier, earlier last year, my years are going together, earlier last year when we first began going into those 34 challenges, we were only meeting once a month. When we start receiving challenges, then the committee meets very quickly to ensure that we're not violating those statutes.
What's about the average amount of time, would you say?
We received those 34 at one time, so that was a longer, some of them were
I can imagine.
very long, so that took a little bit longer, but typically we meet within, what would you say, 2 weeks?
Okay.
And I wasn't referring to the books that are currently in challenge.
Mhm.
I'm referring to the books that have already gone through, have already been deemed an age appropriateness, or that there may be materials that they feel are not appropriate for that age. So not the ones that are gonna go into challenge, the ones that have already been looked at, that already have a little flag saying this may not be age appropriate. And that the kids have to get a permission slip home and the parents have to sign it, or, to allow the child to take the books.
So at this time, we only have one book as well that's in our media centers and it's in high school that requires parent permission. So that one does require that. Now, if the committee deems though that the book is not age appropriate, because remember that's one of those pieces that needs to be evaluated, then it is flagged. So remember we have some of our schools are K-8 schools. So that media center is one media center that serves all students in kindergarten through 8th grade. So some of those books may need to be flagged that it is not appropriate for a 4th grader to check that book out, but it is appropriate for a 6th grader to check that book out. So that becomes part of the guidelines, and that decision is then stems from that ad hoc committee. So again, it kind of goes back to all of the details surrounding the book that the committee really has to think about the school, its population, who's serving, the content of those materials. So that's where sometimes you will see that a book has a grade band on it. It is also why a lot of times, and the comment has been brought up before, no two books necessarily have the same recommendation. And it goes back to what Kathy said earlier of the committee that's there, those individuals that are serving, and the book is different. Each one is different and has to be evaluated differently. But as it stands right now, we have one that's in our media center that requires parent permission. We have many that are tied to advanced courses that require parent permission. So that is different though in those cases.
Can I ask a question that's probably already been answered, but the people that are on the ad hoc, they do have to read the book that is.
In its entirety.
Okay.
It's one of the very first steps. Everybody gets a copy of that book, and when individuals show, and members of this committee can say, a lot of times they will come with their books flagged on different sections and areas that people are going back, and you're having those conversations around it. But part of that process is the book and its entirety to make sure that the book as a whole is being evaluated, which also goes back to our processes and the Miller test.
So do you feel that that should be the case with even us if we're having an issue where we're wanting something to be taken out, that we should have to read the whole thing also? Do you feel that that's a legitimate?
In the objection form, it does ask the individual if they have had the opportunity to review the material in its entirety. So the form does come to us in that question being asked based upon the person who is submitting the objection.
In the appeals process as well. So when it goes through to the board, the expectation is that the board has read the book in its entirety. I wanted to go back to something Vanessa said though. For the age level appropriateness, maturity level appropriateness, those are things that we already do. So in choosing elementary or middle or high school books, that our schools ensure, based off of those grade level bands, that we are choosing books and putting them in the appropriate, by their age level and their level of appropriateness for maturity. So I didn't want you to feel like this was changing something. We already make sure that we are doing those processes in schools. So it might be where once something comes up in the challenge, that we're like, that really should have only been available for 6th graders, that it maybe was in one elementary school and we see that, and it's a recommendation of that really should only be available for 6th grade and up. And I think you were still on your part.
So just in summary, we just want to assure you that we are continuing to monitor legislation and that we do have to adhere to any legislation that is approved. And so it does change our process. Every time a new piece of legislation impacts this, then our process will also be impacted. And so we just want to give you the assurance that when these changes happen, that we will bring back to this committee and have a discussion about how the process is changing and get input as well. So that's it.
Okay, so now I want you to take a deep breath because we're completely switching gears. Go ahead.
I think I misspoke earlier, and I just want to correct it before we move on to this. It was out of the 23 school districts, 175 books were flagged, 84% were removed for pornography. I think I said 84% of their books, and that is so far from the truth. I do not want to be misquoted from that.
Thank you. Okay, so we're gonna flip gears for just a minute to go back to the media materials purchase process. So inside of your folders, you have that process document. We reviewed this process document in our last meeting. It was when we did the sticky notes activity, and we had some discussion around this process. So I'm going to give you about 1 minute so you can review through it again. We're going to have public comment, and then Melvin is going to bring us back to be able to come to a consensus, hopefully, for our recommendation of support for the media process, not the challenge materials, the media process document. Melvin, would you like me to call the names for public comment, or do you want to do that?
No, you can.
No, they're reading it, yeah. I was going to use my teacher fistify for how much more time you need, but then I didn't know if you would understand what I meant. Is everybody good? Okay, let's turn over to Melvin.
Okay. All right, so, so right now, before we start our public comment, I do want to just, first and foremost, Kathy, Corey, thank you guys so much for coming in, giving us a clear clarification on the Miller test. You didn't have to do that, but we greatly appreciate that you guys took the time to break down and really explain it. And I know I had a better understanding for it, and I hope that the other committee members did as well. So thank you guys tremendously. Mental clap. Okay, so I do want to just go ahead and go over the rules for public comment. Any individual who desires to address the Curriculum Advisory Committee at the beginning of the meeting concerning an item on the agenda of a regular or special meeting or any other matter relevant to the operation of the school district may file a written request prior to the start of the meeting by giving the parliamentary, I think we already got through that part. So concerning public comment, speakers shall be called to address the Curriculum Advisory Committee in order in which each has submitted a card. Each speaker shall have one opportunity to address the school board for a maximum of 3 minutes. Inappropriate or irrelevant remarks shall be ruled out of order by the parliamentarian or chairperson. Any speaker continuing with such remarks shall be required to relinquish the lectern. As I said at the last meeting, we are all adults here. We know how to communicate. We all live in the same community. We do 90% share the same interests, and we all want the best for our children. I think we can all agree on that. So any irrelevant comments do not need to be made. And make sure you make your comments, please, specifically to the advisory committee. To ensure that the Curriculum Advisory Committee has time necessary to consider the issues, the public comment portion of the meeting shall be limited to one. Are we doing an hour for public comment? I mean, we only got 14, so we don't need that much time. If there are more than 20 individuals desiring to speak, there's not. So you guys will have the maximum of 3 minutes to speak. No more than 50 individuals will be allowed to address the Curriculum Advisory during public comment. So I think we have all that covered. And as I said before, guys, you get heard a lot better when respect is given and respect is mutual. So please just speak as residents and communities of Lee County and silence your cell phones. Okay.
I thought I did. Turn it
Okay, we're gonna make sure we use the microphone tonight, so as you come up for public comment, if you can just, like a little piece of black tape, and then I'll call 2 names and one can wait here. So first is Dr. Paula Powder, and if I say your name wrong, I apologize. And then second is Eileen DeLuca.
Miss Porter, so. I have bad handwriting. I'm Dr. Paula Porter. Just to give you a little bit of thing about background about me, because I consider myself a credible person. I have a PhD in education focusing on instructional design. I have a master's in English. I have a bachelor's in journalism and another one in elementary ed. I taught 5th grade in Iowa, and I also worked for an outdoor education center, created their curriculum in Nebraska. I teach teachers at the master's, actually bachelor's, master's, and PhD level, and I taught a lot of children's literature classes to our teachers that are out there today. So I noticed at the last meeting of this committee, there was a question about literary value, and we've been talking about that tonight. I'm very happy with that. I'm very happy with the process you guys are doing. I think it's very wonderful. It's better than some of the other processes I've seen in this state and other states. But I kind of want to talk about literary value because it's defined as a quality of writing and the ability to engage, inform, inspire, and teach children. Determining literary value in children's books is a subjective process. We all kind of know that. But when looking at the literary value, we look at theme, we look at the moral of the story, we need to determine if the language is appropriate for the age of the reader, if the characters are relatable to children, and if the story has a clear beginning, middle, and end. These are some of the criteria that I teach in my children's lit classes to undergrad teaching education majors. We have a whole checklist of things that we look for when we talk about these books, and yes, those students have to read the books before we even talk about them as well. But the most important element in determining literary value is that it transcends age. It's a theme that transcends age, culture, and historical content. And it's the message that's explored through the book. And yes, some books that we have out there today do have sections that may be offensive to some, but again, it goes back to the Miller rule with the whole of literary value. The idea of this is that we want to improve our children's critical thinking about what they're reading and not just regurgitating information. Reading a variety of topics and themes can impact children's critical thinking skills by exposing them to new ideas and perspectives, encourage them to question and evaluate information, and importantly, help them determine their own ideas and opinions. Reading a variety of books with different themes can help children develop empathy, creativity, and problem-solving skills, all necessary soft skills needed for adult life. I have researched and have several checklists that are from this state, from our classes that I've taught, and everything else, if anybody wants to see any of those. But, you know, one of the things I try to tell my students, just as we have a poor diet of, you know, Coke and potato chips, is going to affect the physical health of a child. Giving them one focused topic in literature is going to affect their emotional and intellectual.
Sharon McGill is up next.
Dr. Sparrow, Dr. Whitlock, and members of the committee. My name is Eileen DeLuca, and I'm the parent of 3 children who attend Lee County schools, and I've also been an educator for more than 28 years. Thank you all for the work you're doing on this challenge process. It's difficult work, but you're doing a great job. Know that there are many of us here in Lee County who are here to support you as professionals when you make educational decisions to allow continued access to books for children. I believe educational professionals with input from parents and community members should make final decisions, not those with a political agenda. As a parent, I'm concerned that extremists have insinuated themselves into the planning process. We need to be very concerned when educators are not the ones deciding which books are appropriate for children, and when special interest groups want to control what we can and cannot read. Media specialists and classroom teachers are highly educated and trained experts in literacy and in judging whether or not material is developmentally appropriate. In addition to holding degrees, they undergo a great deal of continuing education to remain certified, as you all well know. They belong to professional organizations of other highly trained experts to analyze and recommend literacy materials. Let's let the experts do their job without obstruction. As an educator, I'm concerned that removing books from libraries and classroom shelves is a slippery slope. I can tell you as a former high school teacher and college professor that successful students are students who read and read a wide variety of material. This is how they acquire advanced vocabulary, sophisticated syntax, and the ability to analyze text and synthesize meaning from a variety of texts. Students who read from all genres do well on assessments, become good writers, and demonstrate high-level thinking. These are the skills that are needed to do well in college and in life. If we start removing books from shelves because a few folks have concerns about certain topics, we cut off access to college readiness for students who may be interested or connected to that topic. To use an example from a previous meeting about dragons, if a student is interested in dragons and a few extremists are offended by dragons, removal of dragon books may be the very thing that turns that student off to reading. Conversely, if we offer students the ability to have a personal transaction with a topic that resonates with them, such as dragons, it may open up a love of reading that will support them as they reread the required novels, textbooks, and nonfiction they have to do in college and in other aspects of life. Also, we need to avoid the slippery slope of banning topics such as dragons, which then may empower extremists to ask for the removal of a book that include powerful female dragons, inspiring dragons from minority or historically marginalized groups, dragons who speak a language other than English, dragons who come from a low SES.
Your time expired, ma'am. I'm so sorry.
Okay, thank you, sir. Thank you for your time.
And Marty Cox.
Good evening, everyone. Thank you for the time to speak. As we kick off National Library Week this week with the Right to Read Day, we should all pay our respects to all of our librarians who are professionally trained and committed to the children in our schools. You know, all of this really is about parental rights and children's rights. And what's happening is parental rights are being taken away by a small group of people who have decided they want to insert their particular special interests into our school district. Out of those 34 books that were challenged that year, one challenge was submitted by a parent. One. All the rest of them were submitted by a special interest group. And so that should tell you something right there. Our parents trust our librarians and our schools to do the right thing. And it's when you have these special interest groups that come in and try to insert themselves into the district is when parental rights are taken away. And that's not what we want. We want parents to be involved. We want parents to take responsibility for what their kids are reading. They should know what they're reading. And by getting involved, that's how they do it. You know, we got this challenge form. And it was a good form, with due respect. But there are several things that could be updated on it. Let's see. Okay, one of the things is you continue to require that a form be filled out for each challenge. Every single challenge has to have its own form. And it has to be filled out in its entirety to be acceptable, as you proposed, Attorney Bruno, for the appeals form. The challenge must affirm that the person challenging the book has actually read it. There's no excuse for anybody to challenge a book if they have not read the book in its entirety. Okay? And I'm wondering, out of those 34 books, how many were actually read in their entirety. So I think that should be a line on the form that actually says it has to be checked I affirm that I have read this book in its entirety. And then the specifics for any challenge, including the attached page numbers, the specific lines being challenged, must be included for the form to be accepted. Otherwise, the form should be returned to the challenger.
Sorry, Ms. McGill, that's your time.
Thank you.
Thank you. Robert Rover is next.
Hello, I'm Marge Cox. I'm a resident of Bonita Springs. I have a K-12 media services license in Florida, but I retired from Collier County Schools in 2020. I come here this evening to say yay raw for your media specialists who have worked hard in this. Obviously, have been doing a good job if only one of those books was actually taken off, and I honor them in what they're doing. As a part of my media license, I have a Master's of Library Science. In that, I had a full semester course on collection development. As a part of that collection development, it is to teach us as pre-librarians to have a collection that will not reflect just my viewpoint, but all viewpoints to be represented. And obviously your media specialists have done a great job of that. Today is Right to Read Day. I hope the time will come when every day is a Right to Read Day. Thank you for your time and your hard work. Your committee is amazing.
Lori Brown is next.
This book was found on the Lee County School District's library shelves. I want to show you a few of the illustrations. I could show you a lot more. It shows a little boy and a little girl masturbating. If media specialists approve this book, can we trust them to have done the appropriate thing for every book? All parents have rights. One parent should not surrender their right to another parent. No one in history has ever been tempted to commit suicide by the absence of material on suicide. No one has ever raped or been introduced to rape through the absence of material on rape. No one has ever been murdered because a book on murder was not in the library. No one has ever experimented with inappropriate sexual situations because a book cannot be read. No one has ever been indoctrinated by the absence of teaching on it. No one has ever found themselves experimenting with drugs, gangs, disobedience, disrespect, just because the book was not available to them. Parents absolutely have the right to know what books their children are reading or have access to at their schools. The school district is not banning books. Nobody is banning books. No one is even restricting books that are approved by the parent. Contrary to what's been said by some, not a single classic piece of literature has ever been challenged. The level of disinformation being spread at times is breathtaking. There is currently no possible way for a parent to block a book through Destiny without the title of the book. How would you know to block this book if you didn't have the title to the book? If you were a parent, how would you know? And I, by the way, protect your right to adopt this or to have this book in your children's hands, and I would ask you to respect my right if I don't want my children to read that book. And that's all the district is proposing to do, is to flag it, to give each parent the appropriate ability to approve or disapprove of the book. Nobody's asking for the book to be removed, unless the state of Florida does something otherwise. Parents are not extremists. Parents are the professionals. They know better for their own children than someone that's not the parent of that child. It was not a special interest group that signed the forms for those 25 books. It was me, and I am a parent. I didn't relinquish being a parent when my children grew up, and I signed every one of those forms.
I'm sorry, Reverend
Thank you.
Next time, thank you.
Lori Brown. Oh, okay. Christina Miller. And Rachel Adams.
Good evening, my name is Christina Miller and I have two proposals. First, I propose that a book bowl or accelerated reader style quiz is given with each challenge form to demonstrate reading comprehension and increase the odds that someone actually read the whole book. Second, I'd like to propose that when books have been unsuccessfully challenged and returned to the library shelves or have that challenge flag lifted, that there's a special section in the libraries for them boldly displayed to encourage reading them. When you make a big deal out of something, children will make a big deal out of something. The forbidden only strengthens curiosity and entices action. I think my proposal would counteract the attempted damages done by the fringe groups who tend to be neither guardians nor mandated reporters in this community. If they wish to affix the scarlet letter on these books, then let's affix the scarlet letter and bring these books with a vengeance to even more children's attention than they would have if they were just left alone. Literary reference intended, by the way. Some display labels I think should be considered. Taboo books of the week, open books, open minds. Why doesn't a fringe politically motivated group want you to read these? Find out here. Or, any book worth trying to ban is a book worth reading. Thank you.
Rachel Adams. Is Rachel Adams here? No. Liz Matt. And next is Madeline Stewart.
Hi, thank you. My name is Liz Matt, and I'm a citizen of Benita Springs. I just wanted to note, of course, the phone goes to sleep right at this point. Doesn't matter, I know the point I wish to make, which is that the process that we've had described, that we've been following, seems to incentivize nuisance challenges. And that's my great concern, that citizens could tie up good people for endless amounts of time to produce no results and reduce our libraries to a small group of bland books. And that's my great concern. Thank you.
Kathy Horn. Kathy Horn.
Hello, everybody. Thank you so much. This is an amazing committee, and you have a lot of important work to do, so I thank you for letting me speak tonight. I wanted to just go back to the notion of parents being the ones who get to make the decisions. I couldn't agree with that more, and I don't think that you as a parent should make a decision for me as a parent about my child, the books my child can read. So when I hear you talking about parents, I'm happy about that. But we also know that the community members can come in and they can challenge books as well. Now, what I understand is that there were 34 books that were challenged, 1 by a parent, 34 by community members, and yes, they may have been parents in the district, but they are not currently parents in the district.
I do want to call for a point of order real quick. When you guys are referring to the issue at hand tonight, just focus specifically on the advisory committee, not any previous comments that were made by anyone else.
Well, I think it's important, well, okay.
I appreciate it.
All right, well, thank you. I hope that you'll take into consideration that parents who have children in the schools are the ones who deserve the most attention, because as one of my colleagues just said, this could be an absolutely endless process. It can cost the district time that would be better spent on improving teaching and learning for all children.
Angela Vasquez is next.
Hello, I'm Kathy Horn. Is this working?
Yes.
I mostly reiterating other people's points, so I'll keep it short. But a parent's right to choose for their children is a bridge if challenge books are removed from general circulation. So keep that in mind. I want to again reiterate trusting the professionals. And, you know, if a parent, every parent has a right to choose their kids. If a parent wants to limit their kid's education, that's their right, but they shouldn't have the right to limit education for other students. And I don't understand the process of whether the committee or the administration writes these policies. I believe I understand that you're in the process of writing a policy that will be presented to the board for acceptance. And again, I hope that you can find some way to limit nuisance or repetitive challenges that may pull books before they're disapproved for months at a time. So as you write the policies, I hope that that's something you can keep in mind. And thank you all for your time.
Dana Kroger is up for this.
Hello, everyone. If we weren't pressed for time and if it wasn't so far in my phone book, I'd have us all watch a video of my son Lucas reading when he was in kindergarten, a book that I did not know at this time was banned, that we absolutely loved, because, you know, when you have kids, they go finger painting, you think they're going to be the next Caravaggio or Edgar Degas. So the book that he was reading in kindergarten was A Wrinkle in Time, and the movie was about to come out. So, you know, the rule, if you want to read it, if you want to watch the movie, you have to read the book first. So some of the words in the first page of that book that he was sounding out, and I was just absolutely in awe. Frenzied, usually, supposed, grimly, creating at 5 years old. And I'm not going to take all the credit because teachers do a fantastic job of teaching literacy to children. But I am going to take credit for exposing him to reading. And I'm never going to regret exposing him to a book that he absolutely enjoyed, that he felt empowered by, as the main characters were children. And that book has been banned over, like, in several jurisdictions over the years before becoming a movie. And it's a classic at this point. It's a favorite of many generations. We have a tradition of a decades-long appreciation for literacy. We have the Southwest Florida Reading Festival. There have been literacy campaigns trying to get kids engaged in reading, because we know that it has value. We inherently know that. And now we are all of a sudden trying to limit kids' exposure to reading a variety of books. And we're doing that in a way that's very political and not thinking about the education of children, the exposure that kids need to explore topics and learn about things in a safe way. It's on the pages of a book where they feel comfortable. And if they do have questions, they can ask their parents or ask their teachers, as my child and I talk frequently all the time about anything absolutely that he needs. And there's already a process in place in Destiny for parents to limit any topics. We already give medical permission to the schools and things like that online. And I'm up writing notes in the planner person still. But we do all of those serious legal commitments online, and there's already a process in Destiny for parents to do that, if they so wish to do that for their own children. And now parents, working parents like myself, have to go toe-to-toe with people that have no kids in the system, have like a plethora of time to concern themselves with what my kid is reading. If he was reading like that at...
I'm sorry, that's time.
Okay, thank you.
How many more?
One more after Lucas.
This on?
Yes.
Books are something that should never be restricted no matter what happens in the book. Because books are important to me and fellow students. Because half my knowledge comes from books, the other half from, you know, parents and teachers. Every book teaches at least something. And a book never hurt anybody unless, I don't know, you throw it at someone, but who do that? And no one but parents or educators should dictate what we read. No committee, government, or anyone who doesn't know me or what I have the ability to read should restrict books. And literature is literature, so, right.
I'm Dana Kroger from Cape Coral. I didn't really come prepared to address this.
All the way up to the Zoom.
Only because we have people online.
Yeah.
Excuse me, Dana Kroger from Cape Coral. I respect you educators, and I know you guys consider yourselves the professionals. I agree. Put years into your education. But I, as a parent and a grandparent, do feel rather disrespected in this group. And we are not trying to ban, we are not trying to censor. I have gone to the schools, I have looked in some of the shelves when we applied to have my first grandchild enrolled in the school district. We chose then to go to a charter school where we felt we might have a little more control over what was happening, and we inspected some things there. I appreciate the gentleman who also is probably a grandparent back there who spoke this evening. Sadly,
Just a quick point, if you can do me a favor, just focus the conversation towards the advisory committee, because we want to try to avoid acknowledging people outside, so if you can just do that, we appreciate it. Thank you.
It was suggested at the last meeting that we were uninformed, uneducated, and that as the older people, we really had no right to be here or to say anything about these school districts, but I also am paying taxes to this school district. And I also have grandchildren, which I almost am raising on my own. I feel I also have a right to expect a good, clean education for my grandchildren, just because I'm too old to have children. Thank you.
That concludes public comment.
All right. So thank you to everyone who took the time out of your evening to comment and give thoughtful feedback. Right now, we are going to go to discussions or recommendations from the committee on, is the, as far as the media purchase process. Does anyone have anything you guys wanted to share with the directors or Dr. Scarrow on any recommendations? Okay, if you have nothing else, is there anything?
Just one thing, Melvin, just because it came up twice during public comment, and much to Ms. Merchant saying earlier, when we make sure things on being recorded of our challenges, 2 challenges were submitted by parents. It was stated more than once tonight that it was 1. 2 of those challenges did come from parents who had students currently inside. So I just wanted to make sure, since that's been documented more than one time, we had that piece. So I apologize, Melvin.
No, thank you.
And Melvin, if we can do a consensus for support and interest-based consensus of the support of the media.
Okay, all right, so just show of hands for it. I guess, is that what you're looking for as far as an aye?
Up if you support it, down if you don't
Or a
support
thumbs
it,
up.
sideways if you can live with it.
And for our committee members that are on Zoom, if you could please turn on your camera and show your thumb or use your reaction so we can count your consensus as well.
So this is just on the media materials, not
Yes.
the challenge?
Was there any public comment on Zoom? Did you already ask?
We did. We did not have any tonight, Ms. Marchant.
I always forget they're there.
Thank you.
So Melvin, all thumbs up?
And full consensus.
Okay, so full consensus. All right, you have our just support for that. So now we're gonna go ahead and move, to the good of the order. So for the, committee, again, I thank you guys for coming and speaking to us. And is there anyone in the committee that has, yes, Dr. Starr?
Thank you. We did talk a lot about policy, difference between policy and procedure, and tonight we've been talking about procedure. I think it's important for the public in this committee to know that the school board's gonna be talking about policy through Neola a couple times. The next time it's going to be is May 17th. There'll be a workshop where our policies, right, Kathy? Policies are going to be brought forward. It's no public comment at the May 17th meeting. It's an opportunity for the school board to work with the legal team to review the policies. Then there will be a first reading. That'll take place on June 13th. That's when the policies can have public comment, and that'll be the first reading.
And the policies on the 17th will be these policies.
Okay, thank you, Bo.
Is there not a May meeting for us?
There is not, correct? No, there is not.
So we're not meeting again till 2023,
To
24
the
school
fall,
year?
to the fall, is that to the fall, correct? Okay.
Is it on the agenda?
That was the only good to do it for me. Thank you.
Oh, no, I appreciate it. Is there anyone else who has anything for the good of the order? Dave, go ahead.
Yeah, first, I just want to recognize National Media Professionals Week, National Librarians Week. The media specialists and librarians we have are going through a lot right now, so it's make sure you pass your thanks on to them. For those of you who appreciate the challenging job that they have. Also want to recognize April is Autism Awareness Month. As a parent of a child with autism, just, let's remember that those members of our community deserve to be heard and respected. Want to say, since we don't meet again until August, I want to wish those of you who observe it a happy Pride Month. Now it's pretty important for you to recognize and be proud of who you are. And finally, thanks to see the Purple Ladies here. It's nice to see you all again. That's all I got.
Okay, is there anyone else with the good of the order?
Motion to adjourn, Mr. Chairman.
Okay, second that. So, thank you all for coming out. I'm sorry. What is it, after 8? Yes, sir. Let me double check. Yeah, I'm pretty sure. Yeah.